Welcome to the Answers for Elders radio show. Meet the trusted experts who will give you straight answers and will help guide you on the path of later life care. Now, here's your host, founder, caregiver, and CEO, Suzanne Newman.
And welcome, everyone, to Answers for Elders Radio Network. And we are here with Andrea Lee from Legacy Estate Planning in Bellevue, Washington, serving all of Washington State. And I always look forward. Welcome, first of all, Andrea, to the platform. And also, I'm very excited to talk about today's topic. It's very interesting how the timing comes about based on a call that I got today and all kinds of things. So welcome to our program.
Well, thank you so much, Suzanne. I am so excited to be here, and I am so excited to talk about incapacity and the issues that families and individuals might face as they age and then deal with their changing worlds.
You know, I was telling you just earlier, but I got just an earth-shattering call today from a daughter that moved up from California, from parents that are foreign, from another country. They are basically refusing any outside help. The daughter is overwhelmed, and she doesn't even know how to take care of the care for her mother that has declining dementia. And I'm sure you hear a lot of stories like this. And I'm just, when you talk about incapacity and just the management of that, that's the first story that brought to my mind about that. I'm just very interested. Is that a common thing that happens with families?
I think every single family has their own traditions and beliefs and customs and expectations. And in today's changing world, it's so hard to balance, maybe cultural customs, family traditions.
Sure.
And as society changes, I know a lot of people were caregivers to their parents as they aged. And a society has changed a little bit because now so frequently we have moms who are working, whereas before maybe they stayed at home. It's a little bit easier to maybe care for an aging parent. Now it's so unusual to have a stay-at-home parent, whether that be the husband or the wife. It becomes a little bit harder for parents or children, I should say, to provide the assistance that parents might have envisioned as they age.
Right. And it's interesting because, I like what I said to the daughter today. I said, when someone starts losing their capacity, what happens is fear sets in and they hang on to what they know the most, even though it might be detrimental of where they're living or not having, but they resist any sort of change even more so. So there's this dynamic of, well, mom, you really need care. And mom says, no, I don't. And those are the kind of dynamics, I'm sure, that is kind of that slippery slope.
Oh, absolutely. And I think it's coupled with a lot of complex family dynamics that make it so much harder. For example, I've been practicing elder law and estate planning for like 19 years now.
Wow.
And it is not unusual for me to have someone walk into my office. They're 86 years old. They don't see well. They don't hear well. They're using a walker. They're afraid of using the stove. And maybe their kids have said something to them along the lines of, well, maybe it's time to get help. And they're like, oh, I don't need it yet, because they don't see themselves the way that other people see them. They still envision, in my heart, I still feel like I'm 25. I'm not. I have a child who's in their 20s, but that's how I feel.
Yeah.
And that's how even 85-year-olds feel. They still see themselves frequently as much younger and more capable. So it's so much harder for people oftentimes to get the help they need because they can't accurately see themselves.
So obviously, you're there to care for someone and they're incapacitated. What's the first step legally things that you should look at?
Yeah. Well, the first thing I want to say is the best time to plan or anticipate incapacity is long before anyone's even getting close. And that's because, my own mom has dementia, and for the very first 5 years, she was pretty competent, and she would never acknowledge she was the one that had a problem. She always thought it was everyone else, and she was fine. As a family, we knew she wasn't. She could never acknowledge that. So anytime that you're starting planning, whether it's an early stage of dementia, or hopefully you start when you're 40s and then you
Sure.
revisit when you're 50. But the very first thing we need to make sure someone has are those power of attorney documents.
Mm-hmm.
And that's because without those basic power of attorney documents,
Sure.
as an attorney, it's extremely difficult for us to assist a family who's dealing with navigating the challenges
Right.
someone might face as they age.
Mm-hmm. And really, it's difficult to even talk to a professional about the status of a parent if you don't have that document. They legally, according to HIPAA laws, they can't release information to you unless you have some sort of a document. Isn't that true?
Well, that can absolutely be very true. If a parent or an individual ends up in a hospital, maybe geriatric psych, because they've become
Mhm.
violent or combative as they age, can be extremely difficult to get information from medical
Mhm.
providers if you don't have healthcare power of attorney, if you don't have that HIPAA release, because
Mhm.
the medical professionals are not supposed to share information.
Right.
So I encounter that with my own mom, and I hear it very frequently where a child might know that something is going on with a parent, and
Mhm.
they might want to communicate directly with that parent's medical team, but the
Mhm.
medical team is barred from sharing information with that child if
That's
they aren't
correct.
on that HIPAA release, if they don't
Mhm.
have that healthcare power of
Yeah.
attorney. So
Yeah.
that is why one of those documents are so important to put in place
Absolutely.
while people are still competent and
Mhm.
able to execute legal documents.
Yeah. And obviously, healthcare is important, but also financial power of attorney would be something. Isn't that correct?
Well, absolutely. I mean, most people's goals is to ensure their family members have the tools that they can help them in the times of need. And
Mhm.
that healthcare power of attorney is essential, as is that financial power of attorney. Because oftentimes, as people age, and their memory starts to fade, maybe they become a little less organized. The world starts changing, technology just starts reaching into their lives, and they're
Mhm.
feeling a little overwhelmed. If they've
Mhm.
given a trusted child or
Mhm.
friend or loved one or cousin
Mhm.
the ability to help them manage their finances, that's a good way to make sure someone who might be just a little vulnerable isn't being taken advantage
Right.
of.
Right.
If you have someone else that has that power or the ability to
Mhm.
assist you, or if you become incapacitated or
Yeah, yeah. Well, and the other thing I always tell families, which I'm sure you're an advocate for, is whoever that power of attorney is needs to know where all the bank accounts are, what the passwords are to the bank accounts for the, whatever
Mhm.
goes on in that financial, where the deed to the house is. A lot of times these things, they might have a safety deposit box that you have no idea, where it's located or what to do. Obviously there needs to be some sort of an education process with that power of attorney.
Right. So the number one goal, obviously, is to have those legal documents in place, because once we
Right.
have them in place, we can almost always overcome some of the other challenges, maybe not knowing where things might be kept, not having a copy of the deed, not accessing accounts. We can almost always overcome them. It's hard, but we can do it as long as
Mm-hmm.
those legal documents are in place. Now, for our clients, when they retain us to prepare a
Mm-hmm.
comprehensive estate plan, we give them an organizational binder. And in that binder, we give them a list of documents that their
Mm-hmm.
agents might want in the future. And
Perfect.
we give them places to store information, so that if you become incapacitated, if something happens to an individual and their
Mm-hmm.
children are able to find that binder,
Mm-hmm.
they've made it easier for those children,
Right.
so that, or whoever it is their agents are, to access their online accounts, to know where their monies are saved, to know just the various information their child might need. So it's all there together in a nice binder, and the kids don't need to spend hours searching through the house to try to find, their
Yeah.
social security card or something along those lines.
Yeah, or the insurance or anything like that. I'm sure is just all of these different documents that need to happen. So, Andrea, tell me a little bit about how people get started. As far as planning, that's part of the estate plan is what happens if. I'm sure is that's the big overwhelming thing that you address. And certainly incapacity isn't something that you want to think about or deal with. So it's probably not something that people think about when they're thinking about wills or trusts or any other things like that. Those questions come up. I'm sure they're uncomfortable at times.
Yes, and a lot of my clients sit down with me and they say, we just don't really like to talk about the possibilities of accidents or incapacity because it's a
Right.
very heavy topic. And
Mm-hmm.
as an estate planning and elder law attorney, what my job is to guide them through the process.
Sure.
It's making sure we're contemplating things that families might not contemplate.
Mm-hmm.
Sit
Mm-hmm.
down with them and say, well, what if A happens? What if B happens? What if, your child is not able to act? What safety nets do we knit in place? What if you don't have children? What if you don't have trusted individuals who could make decisions on your behalf? What
Right.
alternatives are available to
Mm-hmm.
those individuals?
Yeah.
So,
Yeah.
and then the reality is, not all power of attorney documents, not all estate plans are created equal. There's a
Oh,
lot
yeah.
of
Very
there's a
true.
lot of terrible planning that I've seen in my years of practice.
Unfortunately true.
So I always encourage clients or potential clients to sit down with an attorney who specializes in that particular area of law. So if you want to do estate planning, don't go to a criminal defense attorney who's your neighbor because they might be the best criminal defense attorney in the world, but they might not be able to keep up on
Mm-hmm.
all the existing laws, the current practices within that
Yeah.
area of the law to make sure that a
Mm-hmm.
client has a comprehensive plan.
Yeah, yeah. And Andrea, I want to ask you, I guess, for if a listener is listening to you right now and they're saying, I don't want to sign a power of attorney, I don't
Mm,
want any of these documents. What's the consequences of not having a document like that?
yikes. So
I know I had to say that because I think that's something that a lot of times people don't understand what a power of attorney is.
mhm,
And they feel like they lose control from day
right.
one, and it doesn't work like that.
Well, absolutely. It never works like that. So one of the best parts of a power of attorney is it only gives the agent powers as far as the principal. The principal is the person who signs that document.
Mm-hmm.
The principal gives the powers to their agents. So if someone comes to us and they're hesitant to sign that power of attorney, we can create a special type of power of attorney. We call it a springing power of attorney that is only comes into effect if the principal is deemed incapacitated.
Right.
Now, that's not necessarily my preferred way to draft powers of attorneys because getting someone deemed incapacitated can be extremely difficult. But if someone is genuinely concerned about that, that's a good option.
Mm-hmm.
Now, that being said, the biggest mistake I think people can make is refusing to sign financial power of attorney documents and healthcare
Right.
power of attorney documents because those documents are designed to allow an agent to make decisions and assist the principal only when the principal is unable to manage their own affairs.
Right.
So I signed my power of attorney documents as soon as I started practicing law at age 27 or so.
Mm-hmm.
And guess what? Nobody's ever had to use those documents in all
Mm-hmm.
those years, but I have them
Mm-hmm.
because I acknowledge that even as a 30-year-old, I could be in a car accident. I could
Mm-hmm.
have a stroke. I could fall off a cliff while hiking.
Yeah, you
Terrible
don't
things
know.
happen. You just don't know. So putting those documents in place are not giving up any of your own abilities to manage.
Mm-hmm.
They're simply, it's kind of like the seatbelt in your car.
Right.
You that's all it is.
Mm-hmm.
My hope is I never need my seatbelt,
Yeah.
right? That I
And
drive
what
around.
you're saying is so powerful because I always look at it is the fact that that power of attorney is assigning an advocate for you.
Yes.
Because that advocate, it's either the advocate of someone that who knows your values and knows who, you trust, or it's going to be the guardian of the ward of the state. And unfortunately, that's happened to several families that don't understand that.
Absolutely. Failing to sign that power of attorney really is giving up the ability to make decisions. You're
Mhm.
giving up powers by not signing it.
Right.
Because if you don't create your plan, the state of Washington has a plan for you. And
Yeah.
it might not be the plan that you want. Number one. So if someone fails to sign a power of attorney and then they become incapacitated, our only solution is a guardianship / conservatorship. That's when somebody, it could be your family, it could be an attorney hired by a nursing home or a
Mhm.
hospital, will go to court. An attorney will be appointed to do an investigation, and they are asking that that person be deemed incapacitated in the eyes of the law. And then at that point, you are giving up almost all of your ability. It's a
Mhm.
very litigious, humiliating, potentially
Right.
circumstances for individuals.
Mhm.
Not only is it extremely expensive, it is time consuming, and you do not get to pick at that point who your decision makers are.
True.
A judge or commissioner chooses who your decision maker should be. And maybe they pick the child who has the same political, religious, and ethical beliefs as you, but you know what? They might not pick that person. They might pick the child who has completely different beliefs as you,
Yeah.
or they
Yeah.
might pick a professional who never knew you during your lifetime.
Right.
So failing to sign those power of attorney documents, it's just opening the door to a guardian being appointed by a local court of
Right.
jurisdiction.
Andrea, this is really powerful information. And again, how do we reach you?
Oh, well, I would love for you to reach out. So you are more than welcome to call my office. The phone number here is 425-455-6788, or you can drop us an email at info@waltar, and that's WALTAR.com.
Fabulous, Andrea. And we're going to come back with one more episode right after this.
We at Answers for Elders thank you for listening. Did you know that you can discover hundreds of podcasts in our library on senior care? So visit our website and discover our decision guides that will help you also navigate decision making. Find us at answersforelders.com.